Appeal 2925 continued from our last hearing. Appeal 2927 and Appeal 2928, both of which are being heard for the first time. With regard to Appeal 2925, the applicant Gary E. and Christine F. McLean, property located at 404 West Wayne Avenue in Zone C1, request a hearing regarding an enforcement notice of Radnor Township dated July 31, 2014. Applicant requests relief on one or more grounds, including the following. 1, that the property is a non-conforming use. 2, variance by estoppel. 3, special exception pursuant to Section 280-45J2. And 4, a variance under Section 280-101. Parties present?
Yes, sir. Mr. Chairman, before we start,
Mr. Chairman, before we start, I would like to put a pad out with a pen so that if anybody other than the applicant or their counsel wishes to be a party in a case, they should sign this, put their name and address where they'd want a copy of the decision, and also indicate which appeals they are here for. So that will expedite the mailing of decisions to the appropriate parties. This is obviously, if somebody's standing is contested, that would be dealt with in the hearing.
Okay. Anyone have any objection to that? I think it's a good idea because we're supposed to send within a certain defined time period notice of our decisions. And the people at the municipality don't always know who all those parties are and where they can be sent notices to. So I think it makes sense to do that. And maybe consider promulgating a form in the future that'll be in our package of rules and regulations. We'll consider that.
Mr. Chairman, I put the thing over here. Would that be a good place?
Yeah, as long as everybody here knows where it is. Again, if you're an applicant, you don't need to do that. But if you actually want to make an appearance, not just comment from the floor at the appropriate time, but make an appearance and be a party, then you're going to have to put your name and address there.
And the appeal that you're for.
Okay, counsel for the first applicant, Mr. Flail, you ready to proceed?
we are, Your Honor.
Thank you. You promoted me.
Been known you a long time.
I've been called a lot of things, but never Your Honor. I'll take it the best possible way. Thank you. Oh, wait, you may.
Actually, I think the township proceeds on this. This is an enforcement.
That is correct, Mr. Cohen.
Peter, go ahead.
The township is ready to proceed, put forth our case on the enforcement notice. I'm assuming, since the applicant is also asking for a variance and special exception, is that once we put on ours, they'll respond to theirs, and at the same time, we'll put on their case for the variance and special exception. And then I ask, if necessary, if I can have a chance to respond to those two applications.
Sounds very complicated. But of course, the burdens
Yes,
the burdens of going forward with evidence and the burdens of proof will vary from special exception to variance to enforcement action. So
Correct.
may as well start somewhere.
Okay, great.
Mr. Nelson, you sent me the actual notice, which I don't know if the other members of the board obtained. Did you? I sent it to you. But before then, we had not seen it. Do you want to enter this as an exhibit?
Yeah, I have copies myself if someone doesn't have one, but yes, I was planning to enter it as a township exhibit. If you wish to make it a board exhibit, that would be fine also.
Okay, why don't we, here's the notice, and this is the one that you sent me.
Okay.
And we will...
It's 4 copies. It's the notice with the exhibit on the back.
Let me see what the exhibit is. Above and beyond road service?
Correct, yes.
Okay. So this will be Exhibit T1. Do we have an extra copy for
I do, yes.
one for Mr. Flail?
I already have copies of the notice.
Fine. I have several extra copies. Does
Actually, I have
anyone,
the original.
That's true.
anyone need one? Everyone have a copy? Okay. Mr. Chairman, are we ready to proceed?
Already.
Okay. I'd like to call my first witness. I'd like to call Mr. David, is it Galsick? Galsick, as a cross. As far as the setup goes, you want me up here and Mr. Galsick there? Does that work for you guys?
Would you like these?
Yes, I think he needs that.
Got a couple of them, may as well have them there.
You can just sit there. I'll stand up here, I'll answer your questions.
Shall I swear him in?
Yes, please.
Sir, if you'll stand and raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes, I do.
State your full name and spell it for me.
David Paul Galsick. It's David, D-A-V-I-D, P-A-U-L. Last name is G-A-L-C-Z-Y-K.
Do that one more time.
G-A-L-C-C-Y-K.
Very good, thank you.
Little scratchy.
Okay. Mr. Galsick, where do you live?
404 West Wayne Avenue.
Okay, that's the property at question at this hearing, correct?
Yes, sir.
And besides living there, do you operate a business on that site?
Yes.
And what is the business that you operate there?
It's a AAA roadside assistance company.
And could you briefly describe what your business does?
I install batteries at the location of customers' cars. So wherever the customer breaks down, I go to their location and install a battery at their location or jumpstart the car. Excuse me. Or change a tire or give it gasoline.
So it's basically it's roadside assistance?
It is roadside assistance only, yeah.
And your customers pay a fee, a monthly fee or something for this service, or they?
They pay through the AAA.
Okay. And do you have any employees?
I have 2 employees.
Okay. Is that including yourself or in addition to yourself?
In addition,
And do you have any company vehicles?
yes,
How many vehicles do you have?
6.
And is the property at 404 West Wayne, is that the only location for your business?
Yes,
And are all the vehicles parked at that location?
no.
Okay, where else are the vehicles parked?
I keep 2 in King of Prussia at my in-laws' house.
I'm sorry, keep your voice up and repeat that in.
Can I get a drink of water or something? I'm really scratchy from being on that road all day.
We'll get you
Actually,
some
sir,
water.
you
Yeah,
can-
I just-
If you
from
could
being-
just stand while you testify, I can hear a little better, I think.
Is that fine?
Yeah, it's fine.
Okay.
Just come forward and stand next to him. Right.
Actually,
there we
you
go.
know, mister, why don't you stand right here so you're closer to her?
There we go.
There you go. And you can face her, you don't have to look at me.
And where are the vehicles parked?
In King of Prussia on Crooked Lane.
And the property in King of Prussia, how is that related? You know, do you own that property or do you rent that property?
It's my mother-in-law's.
So you have 2 vehicles in King of Prussia and then 4 vehicles parked at 404 West Wayne.
Yes,
And those vehicles, are they pickup trucks, cars? What kind of vehicles?
pickup trucks.
And as far as the activities, your business activities on the property, the West Wayne property, what exactly do you do there besides park your vehicles?
We don't do any kind of business there. There's no customer traffic.
Do you have any type of office or break room or anything like that?
I have an office.
And where is the office located?
It was on the 2nd floor, but we moved it to the 1st floor.
And is there any sort of, you want a break?
Yeah, I just,
Okay.
from being on the road all day, I can't talk. That's better. Now I can talk. Thank you. There you go.
Now, also, on the first floor, is there any sort of like break room or kitchen area that your employees use?
No, I have a kitchen there, but there's no area for the employees, just a place if they come in, there's a time clock, just to punch in and leave.
And do your employees, do they come pick up the service trucks at your property, leave their cars, and then go, or do they take the trucks home with them?
2 of the guys take the trucks home, the other ones are there for when we need them.
And so you have 2 employees, so both of those guys take the trucks home.
Yes,
And do they park their personal vehicles at the 404 West Wayne property at any time?
no,
Do you store anything on the property, like the batteries or the tires?
No, but I do have some tires from my trucks there. But no, I don't store the batteries there. They're stored in King of Prussia.
Do you, how long have you been in business?
9 years.
And has the business always been on the West Wayne property, or did you have it somewhere else before the West Wayne property?
No, I moved in there. I opened the business up.
Let me make sure that I get, so you started the business and then you moved to the West Wayne property?
Yeah, I started the business, I'm sorry, in King of Prussia, and I moved here to Wayne.
And when
Correct.
when did you move to the West Wayne property?
2006.
And did you first move there as a resident and then move to business, or did you move there both as a resident and a business at the same time?
Both at the same time.
Did you live in King of Prussia before you moved to West Wayne?
Yes, I did.
Did the business ever have any prior name or different name, or operate under a different name?
No.
And just before you moved to West Wayne, the business was entirely located at the King of Prussia residence?
Yes,
or
it was.
property, sorry.
Yes, it was.
Is there any other business or other business activities on the West Wayne property besides your business?
No, there's not.
And does anyone else live on the West Wayne property besides yourself?
My wife and my stepson.
Okay. And is there another apartment in the other building on the property?
I'm not aware of that.
Did you apply for any sort of permits when you moved into the West Wayne property for your business or for your residence?
Yes, I did.
And what sort of permit did you apply for?
A no traffic business permit. For customer traffic, I guess you would call it.
I'm sorry, for,
No traffic business, so no customer traffic.
And do you know what type of permit that was?
I'm not exactly sure.
Did you get it from zoning or Department of Community Development?
I think I got it from the zoning, here in the zoning.
Sir, feel free to take a drink whenever you need it.
Yeah, and if I'm going too fast, you slow me down, so. Did you review any of the township ordinances before you moved your business onto the West Wayne property?
No, I didn't.
I'm done questioning Mr. Galsick at this time. However, I'd like to reserve the right to cross-examine him after his direct testimony.
May I ask a question, Mr. Chairman?
Please do.
Mr. Nelson, what is the township's position as to the compliance of this use in C1? Is it the township's position that this use is authorized in C1 except for the conversion of the house into this use, and therefore it's a special exception that that the township requires?
Yeah. The township's position is they're allowed to convert the residents into the business as long as they get the special exception, which they have not gotten. The township believes most likely that they can meet all the requirements to do that. The only concern we have is whether or not they can meet the parking requirements on the property.
Okay.
Repeat the last part of that, I didn't hear you. Your only concern is what?
The only possible concern we have is whether or not there's enough parking on the property for this conversion.
So, I mean, as far as, when I looked at the case myself, I had a question. But before I even asked that question, I mean, this was attached to the filing, this plan. Have you seen this plan? We should give it.
I actually have not, no.
Well, it's attached to the application, to the appeal. We should give it an exhibit number, an appellant's number. Well, what should we call it? What are we calling the?
Let's go through this.
Because this
Mr.
shows-
Chairman, all I can say is the copy of the appeal I received did not have a plan attached to it.
Doesn't have,
No.
but it shows two buildings on there. And I don't know if you know this, sir, but were both of these buildings residences historically? Is that what they were?
Yeah,
Not sure.
Mr. Cutler, I am going to call Gary McLean next, and I was going to ask
And he
him some
would
questions.
be able to supply that kind of information?
I believe so, yes.
Okay.
He is the owner of the property, so he should be able to answer those questions.
Mr. Chairman. Oh, yes, okay, yeah, I have, this is the plan. Yeah, this is attached to my copy of the application. Well, I got it from the township, so can't blame.
Oh, yeah, no, I got mine from the township also, so,
Well, maybe we ought to go through now and identify the various components of the application and label them now so that everyone can make sure they have what they need and all work from the same page. We call the application document itself applicants A or 1?
Yeah, that would be A1.
A1.
Then we have a site information sheet, which was, I think, submitted in lieu of a deed, but I believe that the...
No, a deed's here as well.
Oh, you got the deed?
Yeah.
We finally, you got a deed? Not in my copy, we don't. Okay, that's where the deed went.
I might be able to help you with that.
Yeah.
That was originally attached in lieu of a deed.
Yeah.
That little plat that you have.
Yeah, and you were gonna...
Yeah, and then you called me and said we need a deed.
Yeah.
And I had provided a deed to the township right after, like the day after I filed the application. So whether or not we need both of them at this point,
Well,
I
I
don't know.
guess the only thing, I was swearing the corner because I thought you were going to bring a deed to the hearing tonight, and I was just...
I have one.
Okay, well, it seems we have a deed already, so why don't we call the site information sheet A2 and the deed A3? Okay. I haven't looked at the deed. Can somebody let me look at the deed?
There's a list of witnesses, which we can call A4.
Actually, I thought the list of witnesses was part of the application.
It
Yeah,
was.
well, in some ways, it all is, but, I mean, I don't know that we'll
Fine,
need to
we'll do it
refer
this
to
way.
that separately,
That's
but
fine.
All of that was in the packages that I delivered here. I made them myself, I delivered them here, so everybody should have the same things
And then
in their packages there.
Yeah, I don't know how it happened, but obviously these documents are...
so this Yerkes plat would be
A5.
A5.
And then we have some photographs.
Photographs are in a separate envelope. Yeah. I think we can label the photographs collectively just
A6.
A6. Yeah, just,
Okay.
mine showed up in a separate envelope, so we could just label that whole thing A6.
Fair enough. And just so everybody understands, we continued this last time. Mr. Flail, for the applicant, graciously agreed to extend our time, so for deciding starting the hearings till tonight, and our time to render a decision after the conclusion of hearings. And that's correct?
Yes, it is.
Okay, so we're all set there.
Again, to clarify some basic facts, just so we can understand what's being said. There are 2 buildings on the property as shown here.
Correct.
And we will find out eventually if they were both originally houses. Which of the buildings or both do you occupy now for your business?
The front building,
The front building, one closest to West Wayne Avenue.
sorry, up
And you
against
have
the
nothing
street.
to do with the rest of the property?
I don't rent the back building,
And where is your residence? Which property?
in the front building,
And which floor of the front building?
second.
Second floor, okay. Now,
And how many employees do you have at this site? You didn't have any.
2.
You have 2 at the site. So you have basically 2 employees and yourself
Sorry, I misunderstood. At the site?
at this particular
One
property.
location? No, I have no employees on location.
Okay,
They're
so
on the road.
The only person on this property is you.
Me and my wife, yes.
Okay.
but I mean, when someone reports to work in the morning, he just goes from home in his truck to wherever you tell him to go, or does he come into the,
They stop in and clock in.
Yeah,
just
so
I know they're
so
there.
that's their place of business, even though they're road employees. Just if they were
Yes.
traveling salesmen, that's their home base.
Yes.
Okay. But now no one lives there except you and your wife
And my stepson, yes.
and your stepson. Now, I think the other point that John was getting to, Peter, was about the township's position. There's actually potentially two issues here. Potentially, I don't know if there are, but there are potentially. First is, when it was converted from residential use, was it done following the procedure, or as Mr. Flail will contend, maybe the procedure doesn't have to be followed because other things conferred an approval or stopped the township from contesting that? And the other issue is this even a use that we could have approved as a special exception in this district? Is it a permitted use in the C1 district? Is the township taking a position on that or not?
Yes, it is a permitted use.
Oh, it is
Yes, and if
permitted
you
use.
want,
Okay.
I can hand to you the, I copied portions of the zoning ordinance, but basically.
Yeah, I read it myself, and frankly, I didn't see it there, but if that's your position, this is an adversary
If you
case.
read under the opening paragraph for use regulations, it's section 47, states that a detached or semi-detached building may be erected or used, and a lot may be used or occupied for any one combination of the following purposes. And then this is the applicable part, provided that the use and conversion of any existing dwelling shall comply with provisions of 280-45 and 280-101.
Which use category relates to this use in this list, as you go on in 47?
What use?
Because our power to grant a special exception would be limited to a
It's
lawful
not-
use.
The conversion, the conversion, if you read section 45, which deals with conversions, the conversion is just going to a non-residential use. So it could be any non-residential use. In this particular instance, the conversion is to an office use. That's, they're operating an office use in a parking lot, basically, on the property.
Yeah,
That's the
so
way-
that would be E and I of
Yes.
section 47.
Okay, so
Yeah.
this,
Office
so
is
everyone
permitted.
agrees that this is an office use, and that's the only.
I mean, that's based on
Okay.
the information we received.
No, I
that's
just
the way
want
we looked at
to
it.
make sure I understand everyone's position,
Right.
because we never receive any kind of a filing from the township. All we know is what's in your violation notice and
Correct.
what Mr. Flail filed an appeal.
Yes, and,
Okay.
and then also just if you then go further under J, accessory uses, number 2 clearly states that a person operating a business can also, as an accessory use, have the residence on the same property.
Yeah.
So long as
that's
it's
the
not
way-
on the first floor, right?
Yes.
And that's not an issue here.
That's not an issue.
Yeah, so
like-
E, I, and J pick up everything that's going on in this
Okay,
building.
good. Then we know where the issue is going.
Yes.
Well, might I say that we do have a partial issue with the fact that we're here over parking. If you read the township's enforcement notice, it doesn't say a thing about parking. What we're being charged with is the conversion of a business property into a residence. That's what the notice says. And it comports with the ordinance because that's what the ordinance says. This is
Yeah,
one of
Mr.
those
Flair, we'll
rare-
have argument on that later if
Well,
that
this is
becomes
one
an
of the-
issue. But
but-
let's get facts in the record first, and then I know everybody
I
will
can clarify,
summarize.
just for Mr. Flail. Yeah, we're not attempting to enforce the parking. However, Mr. Flail applied for a special exception, and in order to receive the special exception, he needs to meet all the applicable requirements. You asked me if we have any problems with this. We don't. The only concern I have, and it's a concern, it's not that I'm saying they can't meet it. The only thing that, when I went through the ordinance, I thought, okay, this is iffy, is the parking, because we didn't know how many vehicles he had. We didn't know how many employees he had. Now we're getting that information.
See, we've jumped the gun now, and it's my fault. I'll take the blame. Because I wanted to clarify certain things so we could understand the context in which we're putting these facts that you're putting in the record. But I didn't mean to start jumping to have everybody join each issue. We wanted to, Mr. Ryan's question was to clarify the township's position.
Correct.
And you're saying it's squarely on the issue of, did they convert some of this from non-residential use without going through the procedure in the code to obtain a special exception?
That is.
And you're not contesting that the use is a lawful use in that district or anything like that. So that's,
Correct.
we have, and we understand there's two properties, he's just using the one property, two houses, he's using one. That's where we are now. Now, when you said that parking, I mean, you were giving us a little view of the future, I guess. We'll deal with that then. Of course, you'll have your chance to dispute that, Mr. Flail.
Yeah, well,
Okay.
the reason
Right now,
I
let's
opened
get
my
their-
mouth on that issue is that there's no notice in their
Right.
enforcement notice that we're being questioned about
Take
parking.
my word that we are not closing the book on that issue yet, and we won't till the hearing's over, so.
Can I ask
Let's-
one question, Mr. Chairman?
Sure.
Has this ordinance, was this ordinance in effect at the time the appellant converted the residence to the residence office?
Yes, as far as, yes.
So this has always been a permitted use in this district by special exception during the time that we're talking about?
Correct, yes.
I don't think that takes off the variance by estoppel, but I do think that that takes out the nonconforming use. If this was a special exception use, my understanding is cannot be a nonconforming use because it is authorized, albeit by
Now,
special exception.
It's a non-conforming property. It's not a non-conforming use.
Okay, fair enough.
The residential use was a non-conforming use, not the one they're complaining about.
Yes.
Now, there is something else, I don't know if it's going to get on the record. Are you the first person, is he the first person to ever make a non-residential use of this property? Or does this have a history?
I don't know. That's one of the questions I...
Okay, is there anybody that's going to put that information in the record?
Well, he's going to cross-examine my client, and he can tell him
Okay.
what he knows. But remember, though, the violation here isn't the establishment of a business, it's the establishment of a residence.
Yeah,
That's what it says.
But when that happened is when it triggered the need to get the special exception that they're saying you didn't get and should have, and you're saying, well, maybe, but I don't need it anymore, or else give it to me
Well,
now.
that-
So
see, I
the
think
point
it
is,
was
when did it happen? When did the conversion occur?
Yeah, that's what
And
needs to be
we're
established.
going to need to hear about
Okay.
that at some point for
All right, as
somebody.
long as we know our parameters, they just shrunk a lot from what I thought they were going to be.
We're not done defining them yet, so maybe they'll expand again. Who knows? Okay. Go ahead, Peter. You have another witness, or?
Yes, well, I completed my direct here. Don't know if the board has any questions or if Mr. Flail wants to ask any questions at this time.
Do you wish to have me examine him now, or do you?
Well, he is your witness. You examined him as of cross, right?
Correct.
So, I mean, if you...
I have a question. Can we
Yeah.
ask a witness question? You said you had 4 vehicles that you park on the property. Do you need to park any of those out in the street, or are they all within the confines of the property itself?
I don't park them on the street, no.
Okay. Are they in the front of the building? Are they parked in the back, or? I'm just trying to get...
In the back.
In the back. Okay. Thanks.
If you want to ask questions relating to the examination that Peter has conducted, you can, or you can just deal with him when you're presenting your case. He's your witness.
I think I'd like to do it now.
Just to address things that have been raised with his testimony. Okay, sure.
Just things that have been raised.
We don't need to be too formal. I just want to make sure everybody gets their chance.
Right. That's all right, thanks. Mr. Galzick, when you applied for whatever permits or licenses that you applied for in 2006, was it, that you moved in? Did you speak to anybody at the township at that time?
I think it was Jim Loper, I think his name was. I'm not exactly sure.
Okay. Did you tell him what you were doing?
Yes, I did.
And what did you tell him?
That I had a road service company where I had no, actual traffic for customers. No customers came to the property. I just had a few service trucks that went out and did service calls. I used it basically as an office.
All right. Did he voice any concern or problems with your doing?
Not at the time, no.
Did you tell him you were also living there?
Yes, I did.
Did you get any kind of a permit for living in the premises?
I have a lease to live there.
No, I mean from the township.
No, they gave me a license
For what?
to operate a business in Radnor
All right.
Township.
But nothing about the residence?
No, sir.
Since you've lived there, have you had any inspection from the rental housing people?
Once a year.
And have they ever told you anything about being in violation of any township ordinances,
Not that I know of, no.
including the one we're here about tonight?
Not until I got the letter.
All right. I think that's all I ask him for right now.
Do you lease the entire building? Or the entire property? Or
The
what?
house, the front, I leased the front part.
The whole front house? Okay. I guess that's Loper that you were referring to, right?
Yeah, Bob Loper.
Yes, Bob Lumber. Yeah.
It was always confusing because there was a Rob Loper and a Bob Loper. One was here and one was in Upper Marriott, and I was always trying to remember which was which. Is that your case subject to reserving your argument at the end, Peter?
No, I actually have some follow-up questions.
Oh, okay.
Then I'll have two other witnesses for my case in chief.
Oh, you will? Okay, cool.
Yeah. When did you move to the property?
2007. I'm
You have
sorry,
to use the
2007.
mic, Peter, please.
Sorry.
One of them.
Okay, so 2007 you moved to the property, and that's when you established a business on the property?
Yeah, I established a business in 2006 and moved there in '07.
Okay, because I think on your previous, I asked you a question, you said 2009. That was wrong?
I don't remember the saying 2009.
I thought you did because it surprised me because I thought it was earlier also, so.
Yeah, no.
But it's definitely 2007.
Absolutely.
Now, you said the township gave you a license. Do you have a copy of that license?
We didn't bring it with us.
Okay, so you don't have one with you right now?
No.
And just, I have some photographs here. I'd like to have these marked as Exhibit T2. Give me a second to hand them out.
What is T1?
T1 was the enforcement notice.
Okay, because that was submitted to us. Okay, that wasn't part of the application. The way it came to me, I was never sure
I
how
only
it
have
came.
3 sets of copies. These are a mixture of photographs. Some of them were submitted by the applicant. I think we've marked them as exhibit,
Yep.
part of exhibit A6, and then there's others that, to be honest, I pulled off of Google.
Pictures of my trucks.
Yeah.
Is this the back building here in this one?
Wait, I'll get to that, yes.
Yeah, because we don't have a...
Can you zoom in on that?
Turn on your screen so that you can get it right in front of you.
Okay, we all set? You ready, Mr. Galsick?
Yes.
You had a chance to look at these photos?
Yes.
Okay, looking at the photo on the first photo of this packet marked as Exhibit T2, do you recognize that property?
Yes.
And that's your property where you live
Yes.
and run the business?
Yes.
Now, in this first picture, there are 3 white cars, a van, an SUV, and then another SUV, or actually, I guess a van, a pickup, and then an SUV in back. Are those all 3 your cars?
No.
Okay, which of those cars are yours, if any?
The front two. The minivan and the pickup truck.
Okay, and those are business cars?
Yes.
And then who owns the car in back, do you know?
No.
And you live in the business right here in front where the 2 cars are parked?
Yes.
And then there's another building in back that you do not rent that building?
No.
Okay, turning to the second page, this is a photo I got off of Google Street View. Do you recognize any of those 3 cars? And actually, let's turn to the third page. It's easier to see them. Do you recognize any of those 3 cars?
Yes.
Which of those 3 cars are yours?
All 3.
And they're all business cars?
Yes.
And when you park on the property, do they normally park in this area?
Yes.
And can you park them around behind the building also?
Yes.
However, in order to park them there, do you actually have to use the driveway on the neighboring property to get in and out then?
Yes.
And then last, this is obviously on the 4th photo, one of your vehicles also.
Yeah, the previous picture was that truck before it got lettered. It's the same
Okay.
truck.
The middle truck there?
Yes.
And once again, this is a picture of the house you live in and your office is in?
Yes.
On the 4th photo.
If I could just interject one thing. If the applicant is using another driveway or some such to access the property, we can't try questions of title or entitlement, whether there's an easement, whether there isn't. And nobody has brought a complaint, like from the holder of such easement. But even if they did, I just caution that we cannot try issues of title here.
Yeah, I'm not asking that. As will be testified later, and is actually in your packet, Mr. McLean owns the properties to the left and to the right of this property.
Okay.
So Mr. McLean actually owns a neighboring property whose driveway they use to access this one because they're parking in this lots.
And Mr. McLean is the
Yeah.
landlord, so
He's a landlord.
presumably he's getting.
So, once again, to give you an advanced look, if you so decide to grant a special exception in this case, we would only ask that a condition be attached that Mr. McLean put an easement over property at 402 West Wayne Avenue to allow them to use that driveway if they continue parking in the driveway for 404.
Does it need to be a formal easement or just a right under the lease?
It could be a license, a written license.
Well, my only concern is if you grant a special exception here, and when the properties are sold, that if we then have problems with one property owner not getting along with the other, and you can't access it, if they're going to use the driveway for parking for this business, we want to make sure that there's access to the back of the property.
And John, we may, and in fact are required to consider, among other things, in considering a request for a special exception, the impact on surrounding properties and the community nature generally,
I
anyway.
agree with that.
So we can contemplate all this, we just can't
But we
litigate issues of
Yeah.
title and contract.
Yeah, exactly. All I was saying is that we can't try an issue of title. We can say that something has to be put on, but we can't get into whether what's there is permitted by real property law or not.
And the township's not seeking that determination.
And if you grant a special exception that permits, on the basis that they have access over 402, which is the driveway that's also in the photograph, that if that property gets sold and he can no longer use it, then one of the conditions is being violated, and he would have to come back in for further relief.
There's also the question of an implied easement if he sold off one of his 2 properties, but
Well,
I won't
that's also
pretend that I'm still a
property
lawyer.
issue, though.
Well, we can't assume there's even any need for an easement here. They can absolutely get in and out of that driveway just by moving the trucks or parking in the back.
Okay, those points have been made. Let's move on, because I'm seeing a solution crystallize in my mind, but I don't want to say anything about it
This is,
until we get to a certain point.
looking at the 5th picture in Exhibit T2, you do not own the white SUV there, correct?
Correct.
However, the pickup truck to the right of the SUV, is that one of your vehicles?
Yes.
And we don't have to worry about the 6th picture. And those are all the questions I have for this witness. Thank you. Mr. Galchuk, thank you very much. I'd like to call Gary McLean as my next witness.
Okay. And sir, if you'll raise your right hand, do you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
And state your full name for the record. please.
Gary Edward McLean.
Mr. McLean, if you can recall, how long have you owned the property at 404 West Wayne?
Since 2005. And you own the two neighboring properties at 402 and 406,
That's
correct?
correct.
And you heard Mr., I'm going to mispronounce it, Galchek? Galsick, sorry. Mr. Galsick described the activities on the property. Is that a proper description of the activities that occur at 404?
It is,
Do any other business activities occur on that property?
not that I'm aware of.
Other than Mr. Galsick living there with his family, does anyone else live on 404?
Yes, I have a second house in the rear.
Okay. And if we're looking at Exhibit T2 on the first page, that's the house with the...
This is a second dwelling, single-family home.
Okay, and does someone live there now?
Yes,
Okay, and who lives there now?
Lino Soto,
I'm sorry, spell that name for me.
Linosoto.
Now, I believe you said there's currently no other businesses operating on the property. Were there any other businesses operating on the property prior to Mr. Galsick's?
No,
So Mr. Galsick, when he moved in 2007, was the first business activity on the property.
that's correct.
And do you know how the property was used prior to you purchasing it?
No,
And you just used it for residential purposes up until Mr. Galsick moved in?
no, it was empty until he moved in.
Did you ever apply for any sort of permits for the property?
Only rental housing. I was planning on renting both properties, so I had a rental housing license.
Did you ever apply for any sort of zoning permit or building permits?
No, I bought the property through a real estate agent, Bill Spengler, who was actually on the board here, and he said it was zoned C1 in the front, and that I could operate, have tenants operate a business here. So I bought it under that assumption.
Did, other than Mr. Spengler telling you that, did you do any sort of research or investigation as to the zoning on the property, what uses could be used on the property?
No, because at the time, it was empty and I was going to rehab it, and I didn't research it at all.
And so you obviously never obtained a special exception to convert the property
That's
to a
correct.
business? Have you done any physical changes to the property?
We upgraded the house in the rear to the present code.
And I'm going to, if you give me a second, I'd like to show you, Mr. McLean, an aerial photo that was taken off of Google. I'd like to have this marked as Exhibit T3. Let me grab one for Ed.
Mr. Nelson, just give me 1 minute.
Yeah. Excuse me?
Just give me 1 minute here.
Of course. Mr. McLean, to help the board orient themselves, could you point out 404 West Wayne Avenue?
This property here,
And that's the property that has the little red balloon with the A in it?
that's affirmative.
Okay. And the little red balloon with the A in it, that's over the back building on this property?
The rear house, yes.
Okay, that's the one with the garage with the apartment above it? Or the...
No, this is all a single-family home.
Okay, but it's the rear building?
It is the rear one.
Okay. And the building with the brownish roof in front of that, that's the building that Mr. Galsick uses?
That's correct.
Now, behind the second building, there seems to be a parking area, is that
Yes,
correct?
this structure does not exist. It's all parking now.
Okay. And that parking actually has to be accessed through
From this common driveway services these two buildings and these two buildings. You can come up here, and you can also come up here to service this and this building.
Okay. And the first common driveway you talked about, that driveway is actually on 406 West Wayne?
Yes.
And that's all the questions I have for Mr. McLean.
Mr. Chairman, can I ask a clarifying question?
Sure.
The exhibit that was marked A5, which is the Yerkes plan, shows 6 small structures labeled as sheds behind the back building, heading back toward what I would call the back property line.
Yes, I demolished those when I took possession of the property.
Okay, the Yerkes plan is dated August of 2014. Is there any explanation why they'd be showing on the plan?
Yeah, I called them up and told them I needed a plan quick, and they got that off some Google map from ages ago.
Okay, thank you.
Yes, sir.
Mr. Chairman, Mr. McLean, you have authorized the use of the common driveway by the applicant?
Yes, they're my tenants.
And so, the lease authorizes, or you've authorized as the landlord, the uses that are being conducted there as described today?
Yes.
No further. Thank you.
Mr. McLean, how large is the area in the rear of 404?
Approximately 50 by 50.
And did you and I measure that this afternoon?
We did.
You're aware, are you not, that the code requires parking spaces to be 9 feet 6 inches by 20 feet?
I learned that today.
How many parking spaces can you get in that area that could both allow for the parking and for the vehicles to leave?
You and I calculated 8.
All right.
I'm sorry, excuse me. Are either of you engineers,
Negative.
surveyors?
Neither.
Thank you.
But if it's 50 feet wide and you have parking 20-foot long spaces on both the area towards the front and the area on the back, the rear property line, that leaves 10 feet for cars to get in and out.
That's correct. When you and I were there, we figured the most efficient way was 4 this way, 4 here, and then leave the center empty so you could back in to pull out.
Okay. And in the front of the property, or towards the front of the property, between the two buildings.
Excuse me, gentlemen, you're pointing to the plan in front of you, which we can't see on the
It's
screen.
usually
It's not as
pointed out.
helpful.
You're talking about
Perhaps
the
you
area
could
behind
use,
the house.
perhaps you could use A5. I think it might be first more instructive, even though you've identified it as inaccurate. Why don't you use A5 for purposes of this exercise?
Is that the thing Yerkes did?
Yeah, I mean, that's accurate as to the locations of the buildings, it's just those sheds aren't there anymore. We hope it's accurate as to the, yeah.
We are told that the sheds are not there.
Yeah, I'm surprised they put a
yeah, I
current
think
date on there
Google
without
picture is
verifying
more
field
recent.
conditions, you know, yeah.
Here's a copy of A5. West Wayne Avenue, rear property line. These are the sheds you testified are no longer there.
That's correct.
That lot is now vacant.
This is the survey I had done when I purchased the property.
Now, there's an area between the,
Hey, Ed, can you grab a mic?
I'm
There
sorry.
we go.
Thank you.
Thank you.
There's an area between the two buildings, the front and rear building. Are there any, is there any ability to park vehicles there?
Yes.
How many?
You can park 2 where you would have egress and access for both, or you could park 4, but 2 of them would be behind existing cars.
All right, so with no restrictions on entry, on access and egress, there would be 2.
Correct.
All right, so between the two areas, you have a minimum of
10,
10 by your calculation.
by my calculations, yes.
Now, during the time that you've owned specifically 402 and 404, have township officials been on either of those premises?
Yes, I used to have a daycare center in here, and they required me to increase the size of the parking lot. So I had to pave more to put the daycare center in there. And then the daycare center folded, and I put a doctor on the first floor.
Were the township officials aware of the fact that you owned 404?
Yeah, they know I own them.
Did they know that there was a business going on there?
Yes. I mean, this is a doctor and the daycare center. They both had licenses to
I mean, on
operate.
404.
They've known about this since day one. I mean, you can't miss it.
And in fact, did we not apply for and receive zoning approval twice on 402?
Yes.
All right, that's all I have for right now.
I'd like you to clarify one thing. You used the word common, or the phrase common driveway a couple times. The driveway that runs between, using the map up there, between the lower property and the property in question. And then there's a driveway that runs above the property in question. Do these all connect up? Is paving all connecting up this whole system?
Negative. The lower driveway goes to the rear where the sheds are pictured and then would stop.
Okay, so you could not circulate in one driveway and out the
No,
other?
I wanted to do that. The township, when I had additional paving done at the school, would not allow that.
Okay. Thank you.
Follow-up question. During all this time, has the township ever cited you for anything with regard to the establishment of the towing business in 404
No,
and combined with a residence in 404?
no. No.
Have you ever had any citations of any kind regarding 404 West Wayne Avenue?
No.
And you've owned the property for 9 years?
Correct.
And Mr. Galzik has been there since 2007, so say 7 years?
Yes.
You're, of course, excluding the enforcement notice that brings us here this evening?
Yes, up until now. Correct. Correct.
Was that directed to me, or did that go to my tenant? The enforcement notice?
Was there any objection over, was there ever any kind of a problem or objection by the township over the fact that you were parking cars the way you're parking cars there,
No.
or your tenants are?
No.
And up till this time, has the area in the rear of 404, which used to contain the sheds, have they been used for parking by either of the buildings in front?
Yeah, the person in the rear parks there, and I also park equipment back there.
Okay. How about the occupants of the front building?
He can, he just chooses not to. I think he just parks alongside of his building.
All right.
Sir, has any of the neighboring owners ever complained or inquired about this activity, to your knowledge?
Not really. I think Capelli Concrete is to the right or below 406. He operates the same kind of building. He has, a house, and then he operates his business in the back. It's a concrete business.
Mr. McLean, did you just indicate that sometimes you park equipment in the back of the property?
That's correct. I'm a contractor. I have a skid loader, pickup truck, big truck.
And where's that business operated out of?
The rear of 406.
Okay. Thank you.
Do you have any other questions for Mr. McLean?
No follow-up questions. Thank you.
Do you have any other witnesses?
Yes, I'd like to call Bill Miller to the stand.
You need to be, you can wrap that, you need to be sworn in.
And you raise your right hand. Do you solemnly swear or affirm that you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
And state your full name. for the
William
record.
T. Miller.
Thank you.
Mr. Miller, can you briefly give a little background, your background to the board, education, employment, please?
All right, I'm a codes official with Radnor Township. At the present time, I'm the interim zoning officer, having been appointed since our director, Kevin Kuchansky. The zoning officer has been activated in the United States Air Force. I've been employed by the township as a code official since 1999, approximately 15 years. I have certifications with the state of Pennsylvania and 14 different certifications from residential through commercial buildings.
And how long have you been employed either by Radnor or elsewhere as a building code official?
I've been here about 15 years, and prior to that, I was employed by the Borough of Westchester for approximately 10 years.
Now, are you familiar with the property located at 404 West Wayne Avenue?
Yes.
And could you tell the board why you're familiar with the property?
This particular property, Mr. McLean has owned. I had done some housing inspections there quite a few years ago. Subsequent to that, I was past the property, observed. Since I came back, I was laid off for a short period of time. I came back in 2010, and a few years after that, I was past and observed all the trucks there. Got concerned about that. I called Mr. McLean up, advised him that it appeared the property had been converted from a dwelling use to a commercial use without a special exception. Advised him verbally at that point that he should obtain a special exception. Mr. McLean is typically the type of landlord or property owner that just a phone call takes to him to bring him into compliance, and he typically will comply by just a typical phone call rather than an official notice, as I had to send later on. Subsequent to that, Mr. McLean must have contacted his attorney, Mr. Flail. Mr. Flail called me, questioned exactly what he needed to do. I advised him of what the ordinance says, gave him the particular sections that are quoted in my violation letter. Subsequent to that, about 30 days or so later than that, I checked, no special exception had been filed. I went over past the property while I was in the area, and it appeared that the property was empty. There were virtually no vehicles in the parking lot whatsoever that particular day. So at that point, I made an assumption that the property had been vacated. Subsequent to that, our rental officers went over sometime prior to my violation letter, July 31st, and in fact said that the rear of the property had some problems versus trash, and also the office, there was an office use on the second floor with 2 employees there making phone calls, taking phone calls for this service. So subsequent to that, based on the fact that Mr. McLean had not filed for the special exception, I sent him the notice of violation that you have before you.
And you have a copy? Okay.
Yes,
you have a copy?
I have the original here.
Okay, excellent. Directing your attention to Exhibit T1, the actual enforcement notice, looking at the second page, can you explain to the board exactly what you found the property in violation of?
Okay, what I had found is that because the property was a residential rental, it had been converted to some sort of a business use. I felt that it was probably just an office use, but it in fact had been converted. And looking at the section 280-47, the use regulation states, the first paragraph in my violation letter, a detached or semi-detached building may be erected or used, and a lot may be used or occupied for any one combination of the following purposes, provided that the use and conversion of any existing dwelling, which this was an existing dwelling, shall comply with the provisions of section 280-45 and 280-101. Then underneath that paragraph, you'll see the direct quotes from 280-45 from our zoning ordinance.
And that 280-45, that requires a special exception in order to convert a existing residential building to a non-residential building?
That's correct.
And so all this enforcement notice, all you're citing them for is the failure to get this special exception for the conversion.
Yeah, that's correct, yeah.
And prior to you first noticing the vehicles on the property, which led you to make the phone call to Mr. McLean. Did you have any knowledge that there was a business activities on the property?
No, not really, no.
Do you know, since this whole matter has kind of blown up, and you've issued the enforcement notice, did it ever come to your attention that the township was aware of any business activities on the property prior to you becoming aware of the business activities? No. Did you, at any time during this process, either before or after issuing the enforcement notice, did you review the township's file on this particular property?
Yes, I did. Prior to sending out the notice that the board has in front of them, I checked the records, and there was no zoning hearing board hearing for a special exception for this particular use.
And did you see any indication of any application or permits issued for this particular use?
No, I did not.
Now, you heard Mr. Gulsick's testimony regarding the township issuing a permit. Did your office issue that permit?
No, we did not.
Do you have any idea who possibly could have issued that permit that he's referring to?
My guess, it was probably Robert Tate in our financial office. Was probably for a business privilege tax.
But if that office issues a building permit, does any notice go to your office or the zoning office regards the issuance of that building permit?
No, it does not.
Or sorry, business permit?
No.
Did you see any building permit ever issued for this property?
Other than the conversion or the construction that Mr. McLean did on the rear unit, no.
Thank you. That's all the questions I have for this witness.
Yeah, I'd like to ask a question. They didn't do something they were supposed to do, clearly. The question is, if they did it now, would it be satisfactory to the township?
I would say so, yes.
So there is
Given
no,
any did they
there's
follow
no
any
objection to the use being made, other than the fact that they didn't go through the step they had to go through before doing it.
That's correct. That was the only purpose of the notice, was to make sure they did whatever procedures that were required by the zoning and whatever conditions the board may apply to the special exception.
Have you received any complaints from neighboring owners?
No, I have not.
Okay. Do you have any questions for this witness, Mr. Flair?
You know, I'd like to have a sidebar with the board and opposing counsel, if I might, before I answer that question or proceed any further. Is that
Well,
doable?
is it on strictly a procedural matter? I mean, we can't go off the record with regard to anything of substance. Not if we're involved. You can step outside with the township solicitor if you'd like. We can have a brief recess.
Why don't we try that?
Okay. Well, we'll recess for 5 minutes.
Thank you.
Okay, I think we're ready to reconvene. And I'm hoping counsel for the appellant and solicitor for the township have some interesting news to give us.
Well, we've discussed things, and what we'd like to, the board, and Ed, correct me if I'm wrong, we'd like the board to, look at the special exception. The township is not opposed to the special exception, would actually support it, so long as two conditions are attached. The first condition is that the applicant prepare a plan showing that they can provide the necessary parking for the uses on the property. It doesn't have to be a fully engineered plan, but it just needs to be a plot plan showing where the parking, how much parking they need and where the parking is that they meet that need.
Does it have to be prepared by a surveyor or engineer, or will you take a tape measure job?
Yeah, take tape measure. We don't need a full-blown engineered plan. Correct, Bill? We don't need a...
I think that would be fine.
Okay. And then the second thing, we just like a condition that so long as the business is on the property, that the outside of the property is kept clean and tidy. Like Bill testified, there were some issues with it being a little bit of a mess behind the front building. We just want to keep it clean, and so it doesn't, we haven't received any neighbor complaints up to now. We'd like to keep it that way, and the best way to do that is keep the property clean.
Well, if they were to keep it other than clean, isn't there a remedy under the township codes?
It is, but we'd like it's somewhat
It's kind of
easier
a
to have it-
strange condition to put on a special exception.
Well, the special exception is to convert a residential use to a business use. They're going to be operating a business, and we just want to make sure that that the outside of the property with the business on it is kept tidy, just like it would be if a residence was being built, being operated there.
I mean, my fear is that if we word it like that, and then a piece of trash blows by the property, do they lose their special exception if it's a condition?
It would be enforced by the township. I mean, candidly, if there is, personally, I would prefer to not add conditions that are a part of other Radnor ordinances anyway, because if as a matter of other Radnor ordinances, you're not supposed to have trash on the property and make it look ugly, then that should be policed through those ordinances and not part of the zoning code. Keep in mind, we're not going to be enforcing this. We have no enforcement power. The board has no enforcement power.
Like I said, we just felt that this was an issue.
Is your mic on, Peter?
Yes, it is. Can you
good.
Here. This was just an issue for the township. This is just a condition we'd like to impose. Yes, we recognize that there's other ways to enforce this, but it's our feeling that by making it a condition of the special exception, it clearly makes it clear to the applicant and to anyone operating a business on this property that this is an important issue for the township.
How about if we put it in, I mean, one way to put it, I don't want to put it at it suggests that the variance goes away if somebody throws a pack.
Special exception.
Or special exception if somebody throws a cigarette pack in the backyard. How about just the appellant is directed to keep the property neat and clean and comply with all township ordinances in that
That would be
regard.
fine, Mr. Ryan.
That way it's not a condition. And, we've said that they have to keep it clean. Would that be acceptable to you, Mr. Flores?
Absolutely.
Okay, is there anyone else here who wants to be heard on this case? No one present? Okay. Well, the chair will entertain a motion if someone cares to make one.
I'll make a motion to issue a special exception under Section 280-45 for the conversion of a dwelling unit to a non-resident use with the proviso that they'll be required to comply with all township ordinances.
And an additional, and can I suggest an additional proviso that the applicant be instructed to prepare a plan designating where the required parking spaces will be set forth on the parcel and to present that plan for review and approval to the township zoning officer.
I wouldn't accept that because I don't believe it's necessary in this case.
Okay. Since it was your motion, I'll withdraw that suggestion.
Okay.
the agreement of the parties, of course, was based upon that condition. Let me ask you a question, maybe before we see which motion we're going to try to get a second for. How does Roberts deal with that? How many spaces would be required here?
I believe only 5. You need 2 each for the 2 residence uses, and 1 for the office as long as it's 300 square feet or less.
Actually, it's.
And we're talking for the whole property. So we say residences, it's because there are 2
There's
residential
2
units.
residences here.
Right.
You need 2
2
spaces
each.
for each residence, that's 4. And then actually, the township's position is, if the office is 300 square feet, it's 1 space for every 200 square feet of office space. So that would be 2 spaces for the office, so 6.
I mean, is it going
Actually,
to
the
accommodate
office is
6?
smaller than that, but we can get 6.
You can get 6,
We'll go
okay.
for 6.
Bill,
I
does
guess
that?
It just occurs to me, we've not been given a request for a variance on parking or relief on parking.
That's exactly right. And my point is, whether or not we say it in this motion, it doesn't matter. They still have to comply with those requirements.
Yeah.
So what
Right.
we add
That
to a
is true.
motion is meaningless.
We just simply exclude parking. We grant the special exception for the use, but exclude parking and exclude anything else. I just don't think that parking's in front of the.
But I do think that if the parties have agreed
Yeah.
to the preparation of a plan that shows compliance with parking requirements, whatever they might be, that we should condition the special exception on receipt of that and review and approval by the zoning officer.
The applicant doesn't really have a problem with which way you handle it. We're willing to
Well, in the interest of
comply.
moving forward, then I'll accept the second, or the amendment.
So then basically we have a motion as amended. Any second to the motion as amended?
I'll second.
Now discussion. By discussion, I think we should be specific then and say, providing a minimum of 6 spaces. Let's just, so there is no room for dispute down the road, and that'll be provided within what time period for the approval of the township?
30 days?
That's fine for us.
Okay, so within 30 days of the granting of tonight, if we vote tonight, or of the issuance of the order?
It has to be the issuance of the
Yeah,
order.
the
I will
issuance of
issue
the
it
order.
quickly.
Okay.
Because the decision doesn't exist until the order issues.
Correct.
Okay, any further discussion on the motion? It's been seconded. All in favor, say aye. Aye. Any opposed? No, motion's carried.
And just
Thank the board for your patience.
Thank you, members of the board.
Before we're done,
Yeah.
how do we specifically handle the trash issue, that they will comply with all township ordinance? They're
Yeah.
directed to.
Bill is waving at me. He's either being friendly, which he is, or he's saying, you know what?
We'll handle it
You know,
through property
I'll
maintenance.
handle it through property maintenance.
Yes.
So we don't have to put that in.
No.
Good.
Okay. All right, now I'm assuming you know what you're going to do with the violation ordinance.
Yeah.
So we didn't have to specifically overrule that. You're going to withdraw it, I suppose, as part of this, because they've now complied.
Upon receipt of the special exception,
Yes.
they've met the requirement
Okay.
of the enforcement notice.
And that's
It becomes
important,
moot.
because it's a $500 a day fine. though.
Yeah. No, it becomes moot. We're not going to pursue it.
Okay.
Yeah, once
good
you
here.
issue the special exception, you would technically reverse the zoning order and order a
Right.
certain permit be.
Because the order wasn't wrong, it just that there's a better way of resolving it.
Correct.
Okay.
Yes.
Okay, thank you.
Thank you.
Thank you. We excused?
You're excused.
There's no excuse for me.
Enjoy whatever it is you're going to do with the rest of your evening.
I'm gonna go save some money. Thank you.
What? Did you give it to, yes, you did give it to me, and I don't need it. Hold on a sec, I've got it right here, somewhere. Gee, I was hoping we could go on another 5 hours.
You guys are trying.
Yeah, here's the deed.
All right, Your Honor. get these two done.
Okay, the next item on our agenda is Appeal 2927. The applicant, Greenstone Development 2, property located at West Beech Tree Lane and Eagle Road, and zoned R2, seeks to construct a home on a lot which fronts on 3 streets. Applicant seeks to classify the remaining yard as a side yard and not a rear yard. Applicant contends that the construction is permitted by right pursuant to Section 284B, it's 280-4B, or in the alternative, a variance from Section 280-20E of the zoning code and/or such other relief required by the proposed plan.
Mr. Chairman?
Yes.
I think that if the only way this could be done is through a formal dimensional variance, I don't think we have the authority to classify roads, yards under the code as anything but what they are. But the hardship presumably would be the fact that it has the additional front yards. But I don't think we have the ability to, under the code, to change the definition of yards from what it is.
John, that's not, let me go through, I think, I wanted to cut to the chase, if we can.
Gladly.
Yeah. This property, as you see, Mrs. Siebert, who owned this property and lived next door since 1979, has sold both parcels, one parcel to people who I believe are present here this evening, actually, and then the second parcel to the applicant, who are a father-daughter team who live locally and they're custom builders. Mrs. Siebert has since moved to Connecticut.
You need to move it the other way to get it in the camera's purview. There we go.
Mrs. Siebert has since moved to Connecticut, and actually Jim Greenfield's her attorney who's present here, and he's in support of the application. What you have here is 2 roads. It's West Beech Tree and Eagle Road. And you'll see, though, you have, of the 4 yards, 3 of them front on a street. There's only 1 remaining yard. And the question is, how should that yard be treated? Should it be treated as a side yard or a rear yard? If you look at the Radnor Code in particular, I'll point out yard requirements for corner lots. And it says you shall have 2 front yards, a rear yard, and a side yard. Well, obviously, in this instance, it appears as if we have 3 front yards. The effect of this is, if this was a corner lot, you would have 3 yards of 40 feet, which are 2 front yards of 40 feet, a rear yard of 40 feet, and a side yard of 20 feet. In effect, that's what we're doing here. We have 3 yards of 40 feet and 1 yard of 20 feet, which in effect is the same thing as the ordinance providing. If you look at 280-4, it's the last definition in that code. It goes yard requirements for corner lots. And it says, in the case of a corner lot having frontages on 2 streets, there shall be provided 2 front yards, 1 along each street as described under section above, 1 side yard, and 1 rear yard. Now, in this instance, we can't have a side yard and a rear yard because we have 3 front yards already. So in accordance with strict construction of zoning ordinances, the least restrictive to the applicant has to be granted, which is to treat this as a side yard. And John, that's where I was coming, that I believe that the ordinance itself provides that this can be treated as a side yard and not a rear yard because it really doesn't specify what it should be.
You're arguing that it's impossible to comply with the ordinance and with the other 2 yards, and since the ordinance doesn't specify a preference, there is an ambiguity and you're entitled to...
Exactly. And as I said, in the effect of it is we're doing the same thing that the ordinance wants, which is on a corner lot to have 3 40-foot yards and 1 20-foot yard, which is exactly what we're doing here. I mean, certainly I can go through, if we do treat this as a rear yard and have it 40 feet, you have a house that's 17 feet wide.
Now, the applicant is your client, and they are the people who own the next door property as well?
No, the people who own the next door property are seated in the back there.
Okay. Are you going to introduce them?
I don't know I don't mind them coming up now, actually, if, again.
I think I'd like to know on the record if they have
Yeah,
any
exactly.
comments
I
on
agree,
this.
I agree.
But is there anything you want your clients to put on the record first?
I would, yeah, quickly, if we're okay, I'll have them go through the, just the exhibits and things of that nature, that's all.
Hi, I'm Anthony Loftus, and
Okay, sir, I need
My-
to spell your name, please.
Anthony
Your last name.
Loftus, Loftus, and we live next door on 502 West Wayne. So we're going to be neighbors of the new house that they're proposing.
You say West Beach Street Lane?
West Beach Street, that's right. yeah. So we have met the guys here getting ready to build this house already. So our only concern was our privacy from their new house to our property.
Mr. Loftus, could you indicate on the plan where your home would be?
Yes.
Okay.
Yeah.
Thank you.
Do you have any objection to it, their house being located as shown there, and that yard being limited to the 20 feet as shown on the plan?
We don't have any major concern except maybe some degree of privacy, like trees or something to that effect, maybe planted to create privacy for us.
Has this been discussed among the parties?
Yes, it has been, and I believe, why don't we, come on up, Lauren. Lauren, you got this.
You'll raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
State your full name and spell it for me.
Lauren Duffy, Duffy.
And just, Lauren, real quick, on Greenstone Development, who are the owners of Greenstone Development?
My dad.
And you?
And me, yes.
Okay.
Yes.
And the question was regarding landscaping, and have you agreed,
Yes, we met, I think it was Tuesday night?
Yes.
On Tuesday night to discuss some options when we start building, how we can buffer the two properties. So we're going to work with them throughout the process.
And actually, it's your desire to have it buffered?
Correct, absolutely. I think it benefits both properties.
Are the parties asking that we or consider having a conditioned the
I don't know
relief
if
granted?
you can, John. I mean, we don't have any problem with it. I just don't know if you can, depending on how the relief is granted.
Well, if we were to grant it as a variance to
you
allow
could put
that
a
yard,
condition on it.
yes, then we could.
Right. Have you talked about what type of buffering you would have? Go ahead.
I'm sorry, who's speaking? She's not sworn.
That's all right, I know.
To give testimony.
We
If you
haven't
raise your right hand-
determined-
If you raise your
Oh.
right, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes.
And state your full name, please.
Mary Loftus. We haven't discussed an absolute plan, but a few options.
Just the level of detail that the parties want to have. If you don't want us to involve ourselves in that, we're not volunteering to do it. I'm just asking you.
If necessary.
Yeah, I'm confident, knowing at least my client, that they're going to live up to whatever they say they're going to do.
Okay.
Question, Nick. Is Greenstone Development the current legal owner of the property?
It's under agreement of sale. The agreement of sale is attached.
Okay, thanks.
I'll go through the exhibits real quickly if the board wishes.
John, did the agreement authorize them to get this variance?
I believe it does, but I have to go
We're
look at it again.
Equitable owners, and actually, Jim, as I said, represents the Mrs. Siebert, so he can come up and, Jim, you may have to be sworn. I don't know if you have to swear Jim in.
I don't know if you need to swear me, but
Well, if you're going to testify to facts, we're going to have to.
I'm not going to, I can testify to facts if you want me to. I was just going to state our support for the application. on behalf of the seller.
But I mean, could you testify to the fact that your client has authorized this applicant to obtain this variance on this
Oh,
property?
yes,
Yeah,
absolutely.
so why don't we swear him in and
Sure.
have him say that?
Do you
And
solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And your full name for the record, please.
James Greenfield. I'm here as counsel for Elaine Siebert, who is the seller of this property. And in fact, we do authorize the application and enthusiastically support it.
all right, so you're not entering your appearance. You're strictly a witness, fact witness here. Okay.
fine.
So we don't have to put them on the list to get notices.
Well, no, you're in support. If you want a copy of the thing, sign the paperwork.
Nick will give me.
Before, just let me clarify. You're seeking approval of the project, and you don't care, I assume that your client does not care whether it's a variance, an interpretation, an order, without getting into the details or any of that. You just support the project.
That's right. We do. The nature of the relief is immaterial to us.
Yes, no, thank you.
Lauren, if you come up real quickly, please. Lauren, you're already under oath and you've already testified. And Greenstone, who are the owners of Greenstone? You and your father?
yes.
And what's your father's name?
Tom Gabbley.
Spell that for me.
Galbally.
And I've marked as A2, and this is a copy of the deed that actually shows Mrs. Siebert as the owner of the property.
Correct.
And then also I've marked as A3, and this is the agreement of sale between Mrs. Siebert and Greenstone Development.
Correct.
And A4 is the plan that I've been referring to previously, showing the proposal and the setbacks prepared by Inland Design.
Yes.
Just one item I want to point out to the board. It mentions lot area required 30,000 square feet in R2. That's incorrect. It's actually 20,000 square feet. This is a conforming lot. So just, there's one error on the site plan. Just want to point out to the board. And then A5 is just, again, showing the surrounding.
Could you show me that, just let me mark that.
Yeah,
on my-
up top, John.
Hold on, let me get that plan.
It's in the zoning table.
In the zoning, no, just let me get it there, okay? Yes, I see the zoning table, okay, say it again.
Yeah, right here where it says 30,000, there is no 30,000 square foot requirement anywhere in Radnor for lot area. It's 20,000.
Okay,
R2 is 20,000, R1 is 1 acre.
okay, so we should reflect, and it should be noted on the copy of the plan retained for the file that on the record this correction was made.
Yeah, and since we're probably going to refer to this plan, or
As
likely
the annotated plan.
in our order, we're probably going
Yeah,
to refer to this.
when I was reviewing the plan for this hearing is when I really realized that it was an error. And then just A5, that just shows the surrounding area. And again, it just greens it in a little bit. Correct?
Correct.
You have to say yes. Okay. And then you also heard me saying, is it accurate that actually if this was a required 40-foot setback, that the width of the house would be 17 feet?
Yes, that's correct.
That's all I would have. Just request the exhibits to be part of the record, please.
Mr. Cornelia, one question. Is there an amendment to the agreement of sale to extend closing?
There is. Where is that? Do you have a copy of it?
I have a question. And this goes to, I guess, interpretation of the ordinance. We know what it says if you're dealing with a corner lot with 2 front yards. The ordinance doesn't cover scenario where you have 3 front yards. Where you
Actually, you have 2 and 1 curves.
Well, so I think that's the point. If it does at least meet that requirement, it has it's a corner lot and it has 2 front yards. So does that mean it has to have a rear yard and it has to have a side yard?
Well, I guess the ordinance says that, but it's an impossibility. The argument that Mr. Cornelia, I think, is making, and correct me if I'm wrong, is that it is impossible to do that.
Well, I guess it goes back to the point you made earlier. If you look at the top of the property, could we call that the rear yard? Because I think that would meet the 40 feet. So then you have a rear yard and a side yard.
You could do that. The other thing you could do is, if there's no opposition, just approve it by order. This is an oddball lot, I have to say. I don't think there's great precedential value, at least I hope there's not great precedential value. I hope we don't have too many oddball lots like this in the township. But if there's no opposition, that's why I asked the question of what kind of relief would be supported. We can write an approval order. I can give a variance. I could, if the board wanted to adopt the interpretation urged by Mr. Cornelia, I could do that. I mean, personally, I have some real sympathy with the impossibility argument. I don't think an ordinance
Except, excuse me, John, I guess my sympathy for the impossibility argument, I mean, my understanding is essentially this plot was carved out of the larger whole in order to accommodate a development.
No, it was done back in like 1918 or 1920 something. This wasn't done recently. It was done a while ago. These are two separate lots.
People bought the lot next door to have a bigger side yard. Yeah, that's what. Existing lot, long existing.
Okay, if I missed this all along, I would like to understand it, because it's very significant to me. So the prior owner historically owned two adjoining lots.
Not until, it did not come under, zoning in Radnor came in effect in 1928. In 1947, up until 1947, it was separate ownership. So after zoning came into play is when it came into common ownership.
And has this lot historically been vacant, or did it have a structure that was subsequently demolished?
It's been vacant, and you'll see, and actually I have some more backup on this too, attached to the agreement of sale is a letter from Kevin Kachansky dated April 22nd, 2014, saying this is a buildable lot. This is a separate buildable lot.
But we're not arguing it's a buildable lot. We're arguing what the width of the house should be. I mean,
right, but it's always been a separate lot.
In other words, the township is taking the position that this is a single and separate ownership lot, and there is no requirement of a merger. Okay. My understanding of the law, and that's, by the way, evolved over time. The older cases required merger much more easily than the newer cases, when it dawned on people that you shouldn't have a rule that says everybody but the neighbor can buy the lot and it's still buildable. And I believe that there has to be some evidence introduced of an intention by the common owner to treat this as a single lot rather than two. For example, if you tear down, you put a fence around everything, and you have a playground that services the house on the adjoining lot, and you really treat it as an integral part of the other lot, fine. But in the absence of that, my read of the cases is that it's single and separate, and certainly the township seems to be recognizing that.
Thanks for the clarification.
I've handed up A6, excuse me, which is just the extension of the agreement of sale.
Is there any further case you're putting on?
That's all I would have.
Is anyone else here to be heard on this? No? Chair will entertain a motion if someone cares to make one.
John, how would you phrase the order?
I can phrase it as the board wishes. The options that I see is approved without going into detail. Another option is to grant a dimensional variance based on hardship imposed by the ordinance. The other would be to say that, it is impossible to comply with the literal requirements given the curvature of the property, along the curvature of the road around the property. Those are the three that I see. We don't even have to get to an interpretation, because the board pleases, because the curvature of that front road and the size of the lot, and it is a single and separate ownership lot, it seems to me that's a physical condition peculiar to the property. I hope it's peculiar to this property alone in Radnor Township that would, could support variance relief. The board, can direct me. I think
We can state the given that because of the nature of the curvature of the road, that there is being provided full front yard width on all road frontages of the property, therefore all other borders of the property other than this one. So it has the unique characteristic of having 3 front yards.
Mm-hmm.
And on those grounds, because that creates a hardship, that we allow them to treat this as a side yard, or if you'd rather, reduce the rear yard requirement
I wouldn't.
to 20.
If you're going to go to a variance, you're approving this house, okay? I wouldn't say that in the future they can go within anything they want to within 20 yards of 20 feet of that property line. We're saying that given the unique, if you wanted to go the variance route, you're saying given the aberrant shape of this lot, they are entitled to relief. But a variance always gives you relief for one house. It doesn't give you something that can expand without coming back to the board.
Given the footprint, I mean, there's not much else they could do. So.
No, I think this is very supportable as a dimensional variance case, given the really peculiar shape of the lot.
I think Brad asked the question because we're probably trying to wonder how to frame a motion. Unless we want to just frame it to grant the approval on these grounds and let John figure out how to.
Well, I guess the most, I'm thinking right now that we don't need to go into the ambiguity of the ordinance because we can give a variance. I would do the variance route, a dimensional variance for this house and this plan. And if they want to change that, they'd build something bigger. That violated that yard. They'd have to come back to us. I think that's probably the most protective, and that's what's before us. They've asked for relief.
So a variance
for
under
this house.
284B.
Yes.
To decrease the rear. Okay.
Yes.
Pursuant to the plans.
I wouldn't go say this is a side yard as opposed to a rear yard, because that suggests you can run the house all the way into the 40, anything less than 40 feet on the other. Just approve the house and approve it by variance so it's clear that they have to come back if they want something more.
So who wants to attempt the motion?
Make a motion to provide a variance sufficient to proceed with the development of the property as shown on the relevant exhibit.
And we'll incorporate that exhibit in the order?
Yes, remember, we always put that
okay.
in accordance with, Exhibit A4 and otherwise, and, the testimony exhibits to the extent consistent with A4.
Have a second on the motion?
Second.
Any discussion?
Yeah, just a question. The applicant has asked for a variance referencing 280-20E, correct?
Yeah, I believe that's the rear yard provision. But then I also say the catch-all or any other relief required in accordance with the plan submitted.
Okay, thank you.
Yeah, we just need I think we're advertised for that, adequately advertised.
Any further discussion? All in favor, say aye.
Aye.
Aye. All opposed? Motion's carried. Two unanimous approvals in a row. Something must be on the water tonight.
It's like Santa Claus.
Okay, next item of business, and the last item of business on tonight's agenda is Appeal Number 2928. The applicant, Baron and Lydia, I'll use the German pronunciation, Gemmer, okay. Property located at 335 South Wayne Avenue and zoned R2, seeks relief from Zoning Code 280-20D1 in regard to side yard setback requirements, a variance that is de minimis, or seeks a variance in regard to the configuration of the property, or applicant seeks to build by right. I didn't make you French. I didn't call you jamais. You never know.
Jim Greenfield for the applicants. This is essentially a request for relief for a tiny triangular piece of a proposed addition that will create a further incursion into the side yard of approximately 5 square feet. In other words, about half the size of this table. The property was rendered non-conforming by change in the code that established new side yards. I think that was the 1974 code. And prior to, this house was built under the 1951 code, which required, I believe, 20 feet of aggregate side yards, the minimum side yard being 8 feet. This was in old District B, as it was defined in the 1951 code. And when this house was constructed, it actually was compliant on the southeast side. That's the right, as you look at the plan, that's to the right side. But the left side, or the northwest side, is actually 15.7 feet. The side yard is 15.7 feet. So under the code, it's now non-conforming. And the addition, where's the pointer? Here we go. The addition wraps around the back over here, and it is this little piece right here. Can you see what I'm pointing to?
Can I do that again?
Yeah. Yeah, let's do this.
The tiny triangle.
Yeah. This will show it about as well as anything. It's this tiny little red triangle here, all of 5 square feet. The additional incursion into the side yard is 1.6 feet from the 15.7 that currently exists. So this to us clearly is a de minimis variance. You can look at it as de minimis in a couple of respects. The additional incursion is 5 square feet, which I think is de minimis under anybody's definition. And the additional 1.6 into the side yard from where it currently is about 10% of the existing side yard, which also qualifies as de minimis.
And the hardship is?
The hardship is that the, let me put the other plan back up. Hardship is that the lot is wedge-shaped. And it narrows significantly from the front line on South Wayne Avenue to the rear line. And in order to place the house on the lot was when it was originally built. If you were going to build it parallel to one side yard, which is how it was built, it had to be built at an angle to the other side yard. And as a result, when the code was changed, you created a nonconformity. So the hardship basically is the configuration of the property. If the Gemmers attempted to comply strictly with the code by not increasing the nonconformity for purposes of building the addition, they would actually have to angle the roof in order to take it more in that direction than the way they want to do it. In other words, it would prevent them, it would force them to angle it to get to stick along the existing non-conforming side yard.
And is that technically impossible? Is it simply more expensive? Is it a preference in terms of the aesthetics of the finished product?
It's not, the aesthetics are certainly a factor. It's not technically impossible, but it certainly would be very, very difficult and much more expensive to do it that way.
I think it's, the question to me is whether on this record, the threshold question is whether on this record the board believes that this is de minimis relief. If the board were to reach that conclusion, then the board is permitted to grant a de minimis variance without a standard showing of hardship. I will point out that the most recent cases on de minimis variances do not require the board to relax the hardship standards. I believe there's several recent ones that say that a zoning board cannot be compelled to grant a de minimis variance, but it is permissible, and you would not need the even the standard hardship required for a dimensional variance if you find it de minimis.
Now, I should also point out that relief was given on similar applications to two neighboring properties. One is 331 South Wayne, which is immediately to the left as you view the property on the plan. And there was, so that one was that the 2002? Yes. That was in a 2002 case heard by this zoning board. The relief sought was an additional incursion into, I think, the rear yard of 35.27 square feet. So that's 7 times what we're asking to do here. And there was a prior appeal in 1997 for 325 South Wayne, which is the next property over to the northwest. And in that case, there was an additional, an incursion of an additional 2.5 feet into the rear yard, covering a total area of 15 square feet. And in both of those instances, this board granted the relief that was requested.
We have an email that came from Peggy Hagan of the Township, and it's transmitting an email from the applicant with a number of attachments which include these the decisions to which you refer. I don't know if these are to be formally entered into the record. I have circulated these to the board, I believe. So that this is, I have 2 things on this. One is the application packet, and the other is its comprehensive email. And at some point, we probably ought to do some exhibit labeling.
It seems to me, you know, that if we elect to treat this as a de minimis case, the only thing we're going to need to reflect in the record, other than the application itself, is the plan.
Yeah.
The rest of it really doesn't bear directly on the case. What happened with relief on one side or the other or something.
Yeah, it's not binding.
We don't need to create a big fat packet of exhibits.
To be perfectly honest, particularly with the directive under the law, but we can't be compelled to do it. It doesn't legally mean anything if it was done for bigger items, and if the board were inclined to grant the variance, unless the applicant has some terrible objection,
No, that's, if you're inclined to proceed that way, that's fine. The only other fact that I would mention, which may help your consideration, is that the property to the right, which is 335 Conestoga Road, is that right? 337 Conestoga Road, has a side yard on the northwest side of only 12 feet. So there are nonconformities and variances that have been granted all around.
I mean, I just from what I'm seeing, I see some real hardship given the shape of the lot, and on this record, I think the board would be, could reasonably find this to be de minimis if it chose to be.
Let's just check and make sure there's no issues we're not considering. Sir, there's another man back here. Are you here on this case?
Yes.
Are you here to oppose or to be heard or?
Support.
In support, okay. Oh, okay. Well, Jim, you want to put the letter in, or do you want to put the
we're
witness
happy
on?
We have 2 letters, which we're happy to put in. If should we mark the supplemental package as A1?
Why don't we do this? Why don't we, the plan, which is the key piece here, is, okay, let's label the front application A1. The plan, which comes next, is A2. The deed as A3. The email from Peggy Hagan to me of November 17, 2014 at 2:58 p.m. and its attachments would be A4. And we'll just put them all in one group. And then you have these letters. Why don't we make the letter from Richard Butkosk, A5, and the Hartnett's, we'll make that A6.
Okay. And we have, if the board has any questions about the variances that were granted some years ago for neighboring properties, we have backup transcripts we can put in. Doesn't sound like you're going to need them, but if you think you do, we have them.
They're really not relevant. It's strictly color commentary, really.
Yes.
Fine
No,
with
the
me.
A2 was the plan, and I just went in the order that they were stapled in my packet.
Okay, there being no one else who wants to appear, do you have anything else you want to put in the record?
No, I think that's, if you have any questions from the applicant, Mr. Gemmer can answer them. Other than that, no.
Do you have
You
questions?
move your
for
exhibits
anyone?
be part of the record?
We do. We move our exhibits be included in the record.
Well, there being no questions for the witness and no one else to appear, I'll entertain a motion.
Mr. Chairman, I would move that the applicant be granted de minimis relief as reflected in the application and on the basis of the plan that has been submitted as Exhibit A2.
There might be a slight change in the plan, but it doesn't affect the incursion into the side yard. There's another, yeah. Is this the current one?
Yeah, we're not dealing with any aspect of
Yeah.
the plan other than this area.
Yeah,
Okay.
as long as you don't.
Right, if that area is unaffected.
No relief is granted as to anything but that area.
That's great.
And did you specifically mention as a de minimis variance?
Yes.
Yes, I think it should be reflected. Anybody second the motion?
Second.
All in favor? Aye.
Aye.
All opposed? You've got it.
Thank you very much.
Thank you.
3 approvals, all unanimously in one meeting. Incredible. If you live long enough, you can see anything. Good night. We'll see you in December.
Hard to believe, Harry.